Assalamu alaikum and welcome to the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. The purpose of this show, as our viewers are aware, is to provide you with some information around legal topics and for me to answer your legal questions and provide you with guidance and assistance on how to resolve those issues that you may be facing. As always, you can participate in the show by calling me live in the studio on the landline number you find on the bottom of your screen and presenting your question live in the studio. That will enable me to ask you some follow-up questions to understand your issue more in depth and to provide you with a more comprehensive answer. If, however, you prefer not to ring in directly into the studio, you may wish to send through your question on our WhatsApp group. That's the second number that you see at the bottom of your screen. If you do choose this option, please give me some background information to your question and present the question in a way that is understandable so that I may provide the fullest of guidance to you. If I am unable to provide that in-depth guidance, I may provide some general advice and also some assistance as to where you may wish to turn in order for further assistance to be provided to you. So moving on, this evening I am going to start by presenting some information to you. It is in relation to UK immigration law and that there was a new policy announcement by the Home Office today and some further guidance given. And so I will go through that because we have received a number of questions around this topic in previous shows and also outside of our shows. This policy which was published today, or this guidance which was published today, is in relation to a concession to the family immigration rules, and this relates specifically to granting longer periods of leave and also early indefinite leave to remain. As I say, guidance of published on the 20th of December, which is today, and it builds on a previous policy guidance published by the Home Office on the 7th of December, specifically relating to family life, either as a partner or parent, private life in the United Kingdom, and exceptional circumstances. That guidance was published on the 7th of December of this year, and this is some further information with regard to that and that particular concession. Now, this specifically relates to and tells us about the early indefinite leave to remain concession made to the family rules. It specifically relates to young adults, those between the age of 18 or above, but under 25. So that age bracket, 18 or above, but under 25, and who are applying under the private life rules in the United Kingdom, under the immigration rules, or even outside of the immigration rules. Now, the aim of this is to provide those individuals within that short category to provide them with a shorter route to settlement. So instead of the 10 years that they would have been required to satisfy under the previous arrangements, the Home Office now has a discretion to reduce that to a 5-year route to settlement. Now, this route is rather narrow when you break it down. I've mentioned the age bracket, so over 18, under 25, but there are some further restrictions in terms of who it does apply to. So the individuals must be young adults. We know the age bracket. They must have been born in the United Kingdom or entered the United Kingdom as minors, so as children. And the Home Office need to assess that it is inappropriate to expect them to complete the 10 years limited leave before reaching settlement in the United Kingdom within the rules that I've already mentioned. This concession will apply to any applications made from the 20th of October of this year, so 2021. So any application submitted prior to that cannot benefit from this concession. Any applications made after today or after the 20th of October can rely on the concession. If you already have a pending application with the Home Office, I'll come around to what you can do in order to ask for the indefinite leave to remain instead of the further limited leave to remain. The Home Office made clear in its policy, and has done previously as well, but more so in its policy and guidance on the 7th of December, the family life guidance that I mentioned, the exceptional circumstances, that settlement in the United Kingdom is a privilege and not an automatic entitlement. So for those reasons, it is absolutely essential that an application that is made seeking indefinite leave to remain, bear in mind this isn't a right to apply, this is a discretion that the Home Office is able to exercise in the applicant's favour, subject to certain criteria being met. It's therefore vital that the application is properly prepared, supported by the relevant evidence to make that case for indefinite leave to remain. Now, the purpose of the 10-year route to settlement is that the Home Office seeks to allow individuals and applicants to demonstrate, or expects applicants to demonstrate, that they are integrated into society. So the rules, the immigration rules as they currently stand, provide two routes to settlement. There's the 5-year routes to settlement, which are in compliance with the immigration rules. Generally, there are financial requirements, there are relationship requirements, there are accommodation requirements, and there are requirements around the English language and ability to integrate into the United Kingdom society. Those I have touched on in previous shows and will not rehearse again today, but can provide some more information should that be necessary. Now, with those applications, the Home Office allows individuals to settle after 5 years. So the probationary period, the 5-year period before settlement, gives time for the applicant to integrate into society and to demonstrate their commitment to settling in the United Kingdom. The Home Office also sees this as an opportunity to test the genuineness of any sponsoring relationship. So if it's a partner who's been sponsored into the UK, husband or wife, then it gives them the opportunity to demonstrate that A, this is a genuine relationship, and B, that this relationship is going to be subsisting for a permanent or a longer period of time. And the Home Office believes that this deters, that the longer probationary period deters any abuse of the system. Those who are unable to satisfy the 5-year route, usually because they don't satisfy the income requirement, or they haven't passed the English language test and are unable to demonstrate that they have sufficient knowledge of the English language as required by the rules, as long as they demonstrate that it would be unreasonable for a child within this relationship to leave the United Kingdom, or that there are insurmountable obstacles, a very technical term which I won't define today, but that there are insurmountable obstacles to family life as a partner continuing overseas, then they would then be placed onto the 10-year route to settlement. And again, the Home Office believes that this allows for the longer probationary period, allows for an incentive to comply with the rules, because at that point there are rules that need to be complied with, and for integration into society. Generally, if an individual is on the 10-year route because they haven't demonstrated sufficient knowledge of English, then the 10-year route is their opportunity to do that. I also, in a sense, the Home Office uses this the longer period, the longer probationary period, to signal that a person should not benefit from the same entitlement as somebody who is able to comply. So it differentiates between those who comply, i.e. they get a shorter probationary period of 5 years and achieve settlement, as opposed to those who don't comply and aren't able to comply fully with the rules, then they have to demonstrate their compliance through the longer probationary period. And the Home Office sees this as a matter of public policy and public interest. And again, those are the guiding principles for why the Home Office seeks to impose those probationary periods. The Home Office, however, recognises that these young individuals who have either been born in the UK or who came to the United Kingdom as young children haven't entered this non-compliance situation voluntarily, and therefore they cannot be blamed for those circumstances. And in recognition of that, the Home Office acknowledges that this very small minority of people within this bracket may be able to persuade the Home Office into granting them early indefinite leave to remain, because the public policy in those circumstances doesn't require them to demonstrate their compliance, doesn't require them to have the longer probationary period. So that's those circumstances in which the Home Office will consider an application for indefinite leave to remain. We are going to proceed shortly to a break. When I return, I will touch upon the immigration rules, specifically what are the requirements and how to make that application. Please then join me back after the break. Continue to send through your questions and I will also answer those. We will be back shortly after this very brief break. Thank you very much. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. I am your host, Riffat Hussain. Just before we went to the break, I was going through the new Home Office guidance in relation to a concession around early indefinite leave to remain for individuals who are over the age of 18 and under the age of 25. I explained the background to the guidance and why the Home Office feels it's necessary and acceptable now to consider some individuals for early settlement in the United Kingdom. I explained that this is a very narrow category of individuals, and in addition to the age restriction, there are some other restrictions in place also. It is a discretion, so the Home Office has the option of rejecting this application, and with the Home Office track record, my guess would be that a lot of these applications will be rejected unless there is a very strong case made with strong documentary evidence to support why discretion needs to be exercised in favour of the applicant. Now, in terms of the requirements, the eligibility requirements, the age I've already mentioned. So the applicant must be aged at least 18 years old or above, but also under the age of 25. Although there is another exception and a caveat to that, which I will come back to. They must have been in the United Kingdom and satisfy one of the immigration rules, in particular paragraph 276A-DE, which requires that the applicant has spent at least half of their life living continuously in the United Kingdom This does exclude any periods of imprisonment or that this individual has met this criteria in a previous application. So if we have, for example, a 19-year-old applicant who was previously granted 30 months leave on the basis that they have been living in the United Kingdom for at least half of their life under these provisions, and then they make a further application, then that is sufficient to meet that particular eligibility criteria. The applicant needs to have been born in the United Kingdom or entered as a child, and they need to have held limited leave to remain on the basis of their family life or private life in the United Kingdom. They must be eligible for further leave to remain. So just because they've had leave in the past does not mean that they will automatically get leave in the future. So the requirements still need to be met under the immigration rules. That is the eligibility criteria, and that is what the Home Office will be looking for when they assess these applications. There are a number of factors that will be taken into consideration when assessing these types of applications. So the age that the person arrived in the UK will be of relevance. The length of their residence in the UK, again, is a factor that the Home Office will look at. The strengths of their connections to the UK are also important. Remember, the purpose behind these policies is integration into UK society, and therefore connections within the UK is an important factor, as is, a demonstration of integration that's already taken place. Consideration of any periods of unlawful stay is another factor that will be taken into consideration. And whether the non-compliance, whether any previous non-compliance was the result of the applicant deciding to overstay, or whether it was because of their parents, because the applicant was under 18 and they did not deal with those affairs themselves. The Home Office will also look at the engagement that the applicant has had with the Home Office and what efforts and endeavours have been made to regularise their status. Again, if they were a child in previous applications, then that has limited value in terms of that factor. The older they are, and depending on how many previous periods of leave they've had, that may be of more relevance and a weightier factor. Any current leave that the individual holds, again, is of relevance, and whether the limited leave to remain will have a detrimental impact on the person's health or welfare. And bear in mind, this is an age category where individuals are moving on to the next chapter of their life. There's, for example, university, maybe further studies, starting a new career. All of these are impacted with limited leave to remain. You can't get mortgages, for example. Loans are more difficult. And so in terms of welfare, there are serious considerations for this particular applicant. And again, it's important to demonstrate that that detriment to the Home Office, and to provide any documentary evidence in support of the application. It's not an exhaustive list, so there could be other factors of relevance that the Home Office will take into consideration, and will decide which factors need to have what amount of weight attached to them. In terms of how the application is made, then the individual will need to make an application for further leave to remain. So generally, this is an individual who will be on the 10-year route to settlement. They will have needed to complete the 5 years. You can't apply for indefinite leave to remain any sooner. So if you've only held limited leave to remain for 2.5 years, this is the first period of extension. You will need to extend. There's no discretion in respect of that. If you have, as an individual who falls within this bracket, been here for 5 years and you're now extending, then this is the point where you can ask for that discretion to be exercised and for the application to be considered as an indefinite leave to remain application. You will still be required to make the application for limited leave, for an extension of your limited leave to remain, but within that application, make representations and provide evidence of the reasons why this application should be granted as an indefinite leave to remain application rather than further leave to remain. And so the Home Office will then consider those and provide a decision on whether or not it has exercised its discretion in your favour. This guidance also touches upon the power that the Home Office now has to grant a period longer than the 30 months. And so ordinarily, any limited leave to remain granted within these categories, the family law, private life categories, is granted for a period of 30 months, and then the individual will apply for an extension. The Home Office now does have a discretion to grant a longer period than the 30 months. And again, we'll look at that on a case-by-case basis with the reasons provided for asking for a longer period and also any evidence provided in support of that. So that's the guidance, as I say, published today. We'll see what comes of that and how the Home Office approaches its discretion and how that discretion is exercised as the months go on and these applications are placed before the Home Office and decisions are then made. There will be at some point some statistics in terms of grants, refusals, and so forth as we go through time. Do remember that there is the option of a fee waiver. So in terms of if you make an application, and I've touched upon this as well previously, if you are making an application under these provisions, you are required to pay a Home Office fee. At the moment, that stands at £1,033. In addition to that, you are required to also pay an immigration surcharge, which for the 30 months adds up to £1,560. You are required to pay those fees. If you find that you are unable to, due to your financial circumstances, paying those fees is likely to lead you to destitution, so you'll be unable to pay for your essential living costs and to look after yourself and your family, then you are entitled to apply for a fee waiver, either partially for either the application fee or the immigration surcharge, or for the full cost of both the application fee and the surcharge. You can still do that with this application. You are entitled to apply for the fee waiver. If that is granted, and you are then granted the indefinite leave to remain because the Home Office exercises its discretion in your favour, then you will be refunded. You won't be refunded if you've got a fee waiver, but if you have paid the immigration surcharge as part of the application, you will then be refunded that element because you are not required to pay an immigration surcharge if you are a settled person in the United Kingdom. And so that's the guidance. But the key message there is the application must be prepared properly with the relevant supporting evidence, because the Home Office's discretion usually means that they will try and refuse if they can. So that's that. Again, the title of that guidance is Concession to the Family Immigration Rules for Granting Longer Periods of Leave and Early Indefinite Leave to Remain. So I hope that's provided you with an update there, some further information and fruit for thought if that is a category that you can benefit from. And I will gladly take any questions that you have in respect of that guidance or any other guidance for that matter, or any other legal matter that you have. So thank you for bearing with me as I've gone through that. Lots of information contained within that. Very, very new, and so we'll see how that pans out. We are coming to the end of our second segment. We will go for a short break. Please continue to send through your questions and I will address those when we come back. Please join me then. Thank you very much. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. We're into the third segment of the show this evening. The first two segments I spent providing you with an update on some guidance that the Home Office has published today. I've now moved on to answering your questions, and we have the last two segments of this programme to go through those. Please do stay with me as I try and get through as many of your questions and catch up with anything that I have missed. So the first question we have is this one. It's quite a lengthy one, so I will read it out just to understand the information in there. I am an Afghan student who came to the UK on a student visa and then applied for asylum in the UK due to the current situation in Afghanistan. I had a preliminary interview and biometric on 27th of September 2021 with the Home Office, but still waiting for a screening interview. Though I need financial support and accommodation to be provided, I have not received any of them. I was also withdrawn from my master's course because I didn't have enough money to pay my tuition fees. So please advise me what to do. What happens to the What happens if the university asks the Home Office to cancel my visa? What should I do to help me receive accommodation and financial support? I have contacted Migrant Help regarding accommodation and financial support several times, but no positive response. Thanks for advice in advance. Thank you so much for taking the time to write that and for providing such concise information, and that's really, really helpful. So you arrived in the United Kingdom as a student, and whilst that student leave was still extant, you then varied your leave and applied for protection in the United Kingdom. What that does is your conditions, the conditions that you had in terms of your student visa continue. So the right to work that you were afforded as a student, you retain that right and you are entitled to continue working in the United Kingdom as an asylum seeker. I'm slightly confused about this section about the preliminary interview with the Home Office and biometrics on the 27th of September. Now, I would understand that to be your screening interview. You wouldn't have any other preliminary interview with the Home Office. It may be that it wasn't a screening interview in the traditional sense due to the pandemic restrictions. The Home Office are limiting the information that they are taking at the moment. And so I suspect that if you have been interviewed and your biometrics enrolled, then that is your screening interview and that is the registration of your asylum application. If that is the case, you should also be in receipt of an ID card, an ARC card, and that usually arrives within 7 to 10 days after your interview. Huge delays with that happening, very intermittent. Some people receive them, some people don't receive them. But I would imagine from that information that you have already had your screening, and that was the preliminary interview that you had with the Home Office on the 27th of September. If that is the case, then you have a valid application. The student visa will have been curtailed in any event, so that would have been cancelled when you made the new application for protection. So you don't need to worry about your university reporting you to the Home Office. The Home Office are already aware that you are seeking protection and have you registered on their systems. Your second question relates to your financial support. Now, you are entitled to financial support through the National Asylum Support Service and Section 95 of that. You are correct. It is Migrant Help that process these applications. You've mentioned that you've contacted them several times, but no positive outcome. You haven't actually said what they have said to you, whether it's a pending application, it's just taking a little bit longer, which again, it's quite common at the moment, or whether they have explained that you're not eligible for financial support. If it is just a case that it's a pending application, then that is something that needs to be resolved urgently. It would be Migrant Help that resolved that, and you do need to contact them again and seek some kind of response from them. If they are saying you're not eligible, then at that point you need to start asking questions as to why not. Is it the case that that interview you mentioned on the 27th of September wasn't in fact your screening interview, and there is no pending asylum application? So that would be the only kind of red flag that I would look out for. Migrant Help can be contacted. We know that there's contact telephone numbers. I'm also aware that their waiting times on telephone calls can sometimes be, you know, hours rather than minutes. They do a 24-hour, 7-day-a-week online chat service. That may be the quickest way of seeking answers from somebody at Migrant Help and trying to see where it is you are within this process. But you are, as an asylum seeker, you are eligible both for financial support and accommodation support. And that needs to be resolved sooner rather than later. If it's not resolved sooner, then you are advised to seek legal advice, because otherwise you potentially are left destitute and homeless. So the best of luck with that, and I hope that that does resolve your queries. If I have missed anything, then inshallah just drop me another message, and I'll pick that up for you. So in the next question I have is, again, quite a lengthy one, so I'll just go through this one. Hi, I am married here in the UK. I have indefinite leave to remain. However, my application for citizenship was refused in 2015, and I was asked to apply in 2023. The reason for the rejection mentioned that there was an overstay. I guess as I was supposed to claim my indefinite leave to remain before my visa ended in June 2012, but the process was delayed due to a lack of knowledge, without realizing how it will affect my citizenship application later. Anyway, I passed my test in July and got it in October and applied for citizenship in 2015. I was told earlier, what shall I do now? Please guide me towards this matter. I'll be thankful. There's just some further information. I came here in June 2010 after I got married in Pakistan. This is one of the most common reasons for refusing for the rejection of citizenship applications by the Home Office, and that is the suitability criteria. In terms of many people think that the suitability criteria only applies to people who have criminal convictions, and that is a misconception. That is a myth. There are many other behaviours and reasons that are encompassed within that suitability criteria. One of them being any periods of overstaying. So in terms of the citizenship application, the Home Office do want to see a continuous period of a 10-year continuous period of compliance. So work from the date that you were granted your indefinite leave to remain, and you need to have 10 years of compliance. So no breaches of immigration rules, no criminal convictions, which includes motoring offences, and no other behaviours that would be considered not conducive to the public interest. And so that's what you need to work with. If that works out at 2023, then that would be 2023. If that works out to be a little bit later, then wait that extra period, because otherwise you face another rejection. But you do need 10 years of compliance to meet that suitability criteria. The suitability guidance is found on the Home Office website, but you would be advised to seek legal advice around your circumstances with all of the accurate dates, so that a calculation can be made of whether or not your next application is likely to succeed or fail before you make that application. You don't want repeated rejected applications, because that does leave a negative mark on your immigration history. So I hope that does help. But from the information you provide, it may be that 2023 is the earliest date that you can apply. But again, just ensure that you've got that 10 years clear for the suitability criteria to be met. Again, if I've missed anything, please do come back to me and let me know. So we have another question. This is from a viewer who unfortunately has a tenant dispute. So we have a tenant dispute, but the tenant has brought legal action against the landlord. The viewer sending the question is the landlord. He has brought a court case against us for not letting him come back. Now, the landlord here, the viewer asking the question, is concerned about the hygiene of the property and the state this property is being kept in by the tenant. Now, the court has ordered that the tenant be brought back into the property and given access to the property. Now, the answer to the question is determined by what agreement you have in place, and there are quite strict laws around when tenants can be required to leave a property. You can't just stop somebody coming back to your property. Essentially, they have a legal contract and a legal right to reside, and therefore the processes, the correct processes, must be followed. If there are concerns about the tenant not keeping to their side of the agreement in respect of hygiene and the maintenance of your property, then there may be remedies for you. But again, there needs to be a legal process, not just close the door and do not allow them to come back. You can't shut somebody out, and you certainly can't shut them out if there's a court order. Come back after this short break, and I will continue to answer that question and present you with your options, and hopefully avoid any contempt of court proceedings against you. Thank you. Assalamu alaikum and welcome back to the Free Legal Advice Show. I'm your host, Riffat Hussain. Just before we went into our break, I was answering a question from one of our viewers in relation to a property dispute they have with their tenant. Our viewer, unfortunately, is trying to take back their property from, as they describe, an unhygienic tenant. But unfortunately, the tenant has brought legal proceedings against the landlord, and the court has found in favour of the tenant, and the landlord has been advised to allow access to the tenant to this property. The landlord, doesn't want the tenant in the property and are wanting to know their options. And as I stated just before we went to that break, that this will depend on the type of tenancy agreement that you have in place. There are different types of tenancy agreements, and the different type means that there are different remedies and processes to follow if you are wanting your property back. Usually, however, these involve some kind of legal notice being provided, and an appropriate legal notice being provided to the landlord, and ensuring that those are adhered to. If the tenant does not then leave in accordance with the notice and in accordance with any agreements that you have in place, then you may wish to approach the courts yourself for possession of your property. But you certainly cannot just close the door and change the locks and require somebody to leave. If there are issues around the agreement, the maintenance of the property, hygiene in the property, then you can speak to your tenant, agree on certain behaviours, certain requirements, although these should probably already be in your tenancy agreement anyway, and then try and enforce those in a proactive and a productive way, so that neither of you are having to litigate against one another. These can be expensive and time-consuming processes. You presumably don't want to be doing that, but do go back to the terms of your tenancy agreement, see which legal provisions apply, provide the correct notice under the legal provisions that do apply, and then proceed from there. But do not act against a court order, otherwise you yourself will find yourself in court for contempt of court proceedings. And that's not going to help your situation either. So that's essentially where you are. There are solicitors who specialise in landlord-tenant issues. You may wish to seek some further advice either from another solicitor or from the Citizens Advice Bureau. It may be if a third party is able to write to your tenant, you can sit down, and then there isn't the heated element of I'm right, you're right, and the conflict. If it's a third party, it might be easier to mediate and get a resolution to the issues rather than to make the problem worse. But I hope you do get that resolved. Clearly not a situation either of you want to be in. Moving on to my next question. Salam sister, alaikum assalam. Can I ask, the Home Office granted me indefinite leave to remain 5 years. Forgive me, my screen just moved. Me and my wife submitted an application on the 21st of September for the second extension, and waiting for it. I have 2 children, both British, 14 and 11 years old. How can... Sorry, forgive me, I'm not sure I understand your question. So I have 2 children who are British, 14 years old and 11 years old. There may be something missing in your question there, brother. I do apologise because it seems incomplete. It just says, how can I please reply thank you? I'm not entirely sure what your question is. If you just want to send me some further information with regards to that, I'll come back and pick that up. I'll move on to the next question for the time being. So I'm a British citizen. My parents are Pakistani nationals and are over 60 years of age. They need care and support on a daily basis. Is there any visa which allows me to bring them permanently here to the UK? They already have 5 years visit visa. This is quite a common question asked by children living in the United Kingdom who have parents, and particularly elderly parents, back in their country of origin, be that Pakistan or any other country. And the issue here is, and I've touched upon this in previous programmes, yes, there is a route to bring your parents to the United Kingdom, but I would advise you to exercise an immense amount of caution when trying to exercise when trying to make such an application. The reason why is the implications this will have for the 5-year visit visa that's already been granted. The application that you may wish to consider and would need to consider if you are wanting to bring your parents to the UK permanently is called the Adult Dependent Relative Application. And that application is precisely for the circumstances you describe, elderly parents needing daily personal care. And the way the Home Office approaches these applications is by looking at what level of care is required. They're clearly a couple, so can they help each other? That's the first factor. Most of these applications that are successful are usually for a single parent, an individual who is by themselves. So that's already a factor that probably will count against you. Age is not a weighty factor. It used to be many, many years ago, but that factor was removed. And the Home Office now focus more on what is the need and why does that need, why will that need be met here in the UK and why can it not be met in the country of origin? When you say they need help with daily care and support for their daily tasks, what are we talking about? Are we talking about things like they need help with cooking, maybe a bit of cleaning, you know, their laundry doing, for example? There's quite a wide variety of tasks that you can get a maid for, you can get somebody, you know, paid help for, that's quite easily available in countries. Or are you speaking of something a lot more complex, severe medical needs? Essentially what the Home Office will be looking for is what evidence are you providing that the need cannot be met in your country of origin or in their country of origin. You know, can you get nursing care? What evidence do you have that shows that you've tried to find this and failed? It can't be a financial factor because you have the finances to support them here, and therefore you can send that money to Pakistan, to your parents, for them to pay for any care that they would require there. So finances can't be the issue. It's why is the level of care they need not available in Pakistan with your financial assistance, and why does that have to be provided here in the UK by you? So that's the consideration. If you make this application and you are not successful, and I've already alluded to this, the implication is that the 5-year visit visa will be curtailed, that will be cancelled, because they no longer meet the requirements. Your parents, by making this application to come and settle here, are clearly saying, we have no intention of going back to Pakistan if we come back to the UK. And therefore, you lose the avenue that you have for them coming to the UK at the moment. And so you lose and lose both ways. If that application for dependent relative application is unsuccessful, they can't then come back as visitors either, because you will not be able to persuade the Home Office they have an intention to return because they've already made an application to remain permanently in the UK. So please, please look at your circumstances objectively. Sit back. Is it really an absolute need that they have, or is it just a preference that they be looked after by their child or children in their advancing years and spend their years? If it is the latter, please don't make the application, because you will fail. And you will also lose the visit visa as well. So I hope that does answer your question. I have a number of questions outstanding, and I'm not going to be able to get through all of these this evening, so I will apologise in advance for that. What I would ask is that I will save your questions and I will pick them up in my next programme. So if there's anything that I don't pick up this evening, please do watch the next programme, and I will answer those for you. One final question. I am from Iran. First time I came to the UK was in 2008. I did an interview, but they didn't accept my case. I've been to court, and I left the UK in 2014 by myself voluntarily. I wasn't deported. I came back in 2020. I've done my screening interview. What will happen next? So very, very briefly, you will have your claim considered as anybody making an application does. So if you've had your screening interview, you will then be invited to a substantive interview to explain your reasons why you are here and seeking protection. Again, the Home Office will have a record of you entering previously. They will have a record of your previous claim, and they will probably ask you about that because you were able to go back after previously claiming that you weren't able to. And that will be taken into consideration in terms of the risk to you on this occasion. But you will proceed through that process. Do seek legal advice, do seek legal representation. You will be prepared for your interview. And you will be, as an asylum seeker, the likelihood is you are eligible for legal aid for that assistance to be provided as well. We are in the final 30 seconds of this programme, and I do apologise because I can see a lot of questions still outstanding. I'm not back for the next 2 weeks. There will be no live show. So inshallah, join us in the new year. Thank you so much for sending your questions through, and thank you so much for joining me this evening. And I look forward to coming back in the new year. Take care. Assalamu alaikum wa rahmatullahi wa barakatuh.